There are two types of contempt of court. In family law, we really only talk about one type of contempt: indirect contempt of court. Direct contempt of court is when someone does something bad in the courtroom, such as cuss out the judge. That's pretty rare. Indirect contempt of court means a judge issued an order, and then later, at some time after that order was issued, someone violated the order. That is indirect contempt of court. It is somewhat like a criminal case, except that the prosecutor is the opposing party rather than a government actor like a taxpayer-paid prosecutor. Contempts involve a higher burden of proof than most family law cases. So if you are charging or accusing the other side of contempt of court, you have to make a really strong case. You cannot take any shortcuts, and you cannot take anything for granted. You will have the burden to prove that not only did the other side violate the court order, they did it willfully. That means they chose to violate the court order. That means they knew about the court order and violated it anyways. If you have been accused of contempt of court, you have to know that if you're found guilty, you could go to jail. You cannot take any shortcuts either. And you have to prove that you did not willfully violate the court order. This could mean a variety of things. You did not know about the court order. You did not violate the court order, or even if you violated the court order, it was unintentional or unavoidable. Proving intent is more than just saying it was intentional or it was unintentional. You have to show by the circumstances and by the actions of the parties that there was intent or not. So you have to perform your due diligence and discovery and have as much information as possible to either prove the contempt charge that you're accusing the other person of, or to prove that you did not violate the court order, or that it was unintentional or unavoidable.